Straightforward conversations, no filters beyond the headlines, just the facts. This is the NewsMaker. Thank you for joining us. I'm Tristan Udalo. Former President Rodrigo Duterte will seek an early dismissal of the crimes against humanity charges against him before the International Criminal Court. Duterte faced the ICC Pre-Trial Chamber on Friday, March 14, to confirm his identity and was informed about his rights under the Rome Statute, which created the tribunal. Duterte's counsel, former Executive Secretary Salvador Mejaldea, questions the legality of the arrest. But is the country ready for an engagement with an ICC, an indication that it is ready to rejoin the international treaty? Today's newsmaker, former Senator and Justice Secretary Senator Franklin Drilon. Senator Drilon, thank you for your time.
Good morning, Tristan, and thank you for having me this morning.
Okay, sir. Simulan po muna natin just your overall assessment of his first appearance, of former President Duterte's appearance at the ICC Pre-Trial Chamber.
Well, it is just a very preliminary hearing to determine the identity and the custody of the accused, in this case, former President Rodrigo Duterte. And other than that, the hearing did not touch on any other matter, including the allegations of lack of jurisdiction raised by former Executive Secretary Mejaldea, which the court said we will take that up when we come back on September 23, if I'm not mistaken. So, yes, it was a procedural hearing. Nothing substantial came out. And overall, it just gave us an idea of what this ICC proceeding is all about.
But sir, would you say that due process was accorded to the former president? Sa lahat po ng nangyari, although it's procedural, would you say na nabigyan po siya ng due process dun sa first appearance hearing?
Yes, due process simply means you're given the right to dispute the charges, to present evidence, etc. And the time will come when the formal trial starts in September. At sinasabi natin due process, baka po yung kaluluwa ng 6,000 namatay doon sa drug war ay bigla na lang tumayo at magsabi, nasaan ang aming due process?
What was your reaction, sir, when you saw former President Duterte appearing virtually, no? Some say parang iba yung demeanor nung presidente from his previous tough talking na talagang iba yung pagtrato niya sa ICC. This time parang controlled or parang iba po yung appearance niya, sir.
Ako bilang dating kalihim ng kawaran na katarungan, sanay na po sa mga ganong klase, sa mga eksenang ganon, sa pagpresenta ng pagharap ng akusado sa husgado. Kaya sa akin walang pagbabago doon.
Sir, former Executive Secretary Salvador Mejaldea called the arrest kidnapping and politicized during mismo po nung hearing last Friday. But how do you think an international tribunal would appreciate this line of defense at the onset of the hearing?
I think that the statement of Secretary Mejaldea is more for local consumption dito sa ating mga kababayan, dahilan po na talaga namang tama, the offenses charged were committed when we were still in members of the ICC at ang proseso naman sinunod. Kaya hindi ko po nakikita kung tama na yung sinasabi ni Secretary Mejaldea, karapatan lamang na iharap ang kanilang depensa at sasabihin na ito'y illegal. Dahilan po ang maraming tanong ng ating mga kababayan, ito bang nangyari legal? The question uppermost in the mind of our people, is this a legal proceeding? And that will be determined only by the International Criminal Court. But for purposes of our domestic audience, Secretary Mejaldea indeed presented what which is expected to be the question raised by our people. And now it's up to the administration to say that indeed the proceeding is illegal. I'm sorry, that the proceeding is legal. So it's at this point, there will be no one who can make a decision until after the court will, the ICC will rule on it come September.
So what should the President brace for in terms of a protracted legal battle? Sabi nga po niya, bago siya lumapag ng eroplano sa Netherlands, it will be a long legal battle.
I'm sorry, what's your question?
So what should the president, what should the former president brace for dito po sa long legal battle? And do you think, sir, that the court will favor an early release for the former president given na yung condition niya po or out of humanitarian consideration?
Former President Duterte has until September 23 to prepare his defenses, particularly on the issue of jurisdiction, although from what I recall, this was raised in September, a year and a half ago, in 2023, and the court already ruled that they have jurisdiction. I guess, as I said, my reading is that the issue being raised on the question of illegal arrest is more for the consumption of the local audience.
Senator Drilon, yung sa 6 years po no, na after Duterte disengaged from the ICC, he is now the subject of a possible trial in court over crimes against humanity. Do you see this as an indication that the Philippines is ready to rejoin the international treaty, and why?
Sa akin, to me, the President should bring back the country under to the Rome Statute, which established the ICC. And indeed, we have, in fact, our theory, my theory when I was in the Senate, we brought this issue of the withdrawal from the Rome Statute. We brought this issue, I led a few senators, we brought this issue to the Supreme Court, citing jurisprudence in the United States, which said that the concurrence of the Senate is needed before there can be a valid withdrawal from a treaty. And so we said, if the Senate concurred in the ratification of the Rome Statute, it only shows that the participation of the Senate is likewise necessary when you withdraw. So we argued before the Supreme Court that asking the Supreme Court to declare the withdrawal as invalid. Unfortunately, the Supreme Court understandably said, no, we sustain Duterte. And that's it. So I believe that just to settle the issue of jurisdiction, etc., the President should reaffirm the membership of the country in the Rome Statute and therefore in the ICC. Why is it necessary? So that, number one, it will settle all issues about jurisdiction. But more importantly, so that if another Duterte comes up in the Philippine politics in the coming years, at least if the justice system in the country cannot provide justice as we see today, then there is no question that another body, an international court, can look at the situation in the Philippines as the ICC is doing now. So in my view, if you ask me, we should go back to the Rome Statute because in the first place, in my mind, in my view, the withdrawal was not effective because of lack of concurrence by the Senate to the withdrawal. The decision to the contrary of that of the Supreme Court notwithstanding. I don't agree with the Supreme Court, especially at the time when it was rendered when Duterte was in power.
Okay. And it would also help, sir, do you see that this would also help the Marcos administration to assert na yung pag-comply natin with international law is not just for mere political reasons once mag-rejoin tayo ng ICC?
Yes, it can be cited as proof that we are a country which adheres to its international commitments as a responsible member of the legal of the national of the international community. So, to me, for a lot of reasons, for a number of reasons, we should again accede to the Rome Statute, and this can be done unilaterally by the president without any need for concurrence by the Senate.
But how is there any way, sir, to ensure that once we rejoin or halimbawa po no in the event na bumalik ang Pilipinas sa ICC hindi pa rin to subject to the personal whim of a future leader, because yung nangyari nga po sa atin, 'di ba, umalis, then halimbawa bumalik, and then by the time na magkaroon po ng similar leader that has the same view on what ICC is, baka po biglang umalis ulit. So yung parang paalis-alis, meron bang way to institutionalize this kind of treaties, sir?
There is no guarantee, but at least you can provide safeguards against the abusive decisions of future leaders that may come to our fore.
Okay. Now, I want to go, although na-touch nyo na po a little earlier yung arrest ni dating Pangulong Rodrigo Duterte. A lot of comments online saying that the arrest of the former president is illegal or there's an unlawful arrest. Yung paulit-ulit din pong pinag-iinitan ng kampo ng dating Pangulo that there's kidnapping. What is your take on the government deciding to tap the Interpol to carry out or allowing the Interpol to carry out the arrest? Legal ba to, sir?
Well, I had said that earlier. It is legal because we are bound by our commitments to the International Police Organization. We have adhered to the Constitution of the Interpol as a member of the General Assembly of the UN when we concurred with that resolution adhering to the Constitution of the International Police and committing our cooperation in the fulfillment of its obligation, which is to make effective the rendition of our criminal justice system.
So yung may mga comment po, including the one from Senator Alan Peter Cayetano saying na may complementarity principle. Could you help us understand, can the ICC only act if courts are unable or willing to act?
Well, I don't agree with Senator Cayetano. I believe that the fact, you just look at the facts. I don't have to argue anything. By the administration of Duterte's own admission, 6,000, at least 6,000 were killed during the 6-year term, more than that were killed during the time of the father of the president for 20 years. In other words, you compare 6,000 by Duterte in 6 years killings and the 3,000 by the former President Ferdinand Marcos Sr. But having said that, how many were brought to court? I think about 3 or 4. The particular, I think specifically the Kian killings. But this itself is proof that that the system of justice, insofar as this issue is concerned, is not working. That is why the ICC had to take over. How can we say that the justice system is working when you can only bring to court 3 or 4 of the 6,000 victims? So that is the single biggest argument against the assertion of my friend Senator Alan Peter Cayetano. The number of cases brought before the courts and the number of convictions. 3 or 4 cases out of 6,000. Do you think that satisfies the standard of the working justice system? In my view, the assumption by the ICC of jurisdiction in this particular case is an indictment of the system of justice in the country, especially when it involves policemen. Because there are several pillars of justice, 4 of them. The first one being law enforcement. If the law enforcement fails then the justice system will not work. In this particular case, how can you say that the justice system is working when the very accused are members of the Philippine National Police? No less than the head of the Philippine National Police is being held. So how can you assert that our justice system is working to exclude ICC from jurisdiction? Obviously, you cannot.
And it's highly unlikely that the former president will be tried here in the Philippines kasi yun po lagi nilang sinasabi, no, better to face a Philippine court tried dito sa Pilipinas than face an international tribunal.
Again, that's for domestic consumption.
Okay.
Because we are members of the Rome Statute, and these offenses were committed while we were members of the Rome, while we were members of the International Court of Justice, and therefore there is no question that there is jurisdiction, especially if you examine the issue of whether or not our justice system has effectively responded to these 6,000 deaths that occurred during the so-called war against drugs.
Senator Drilon, just two more questions. Yung relevance lang po of the petitions before the Supreme Court to nullify the government's engagement with the ICC in case of a favorable ruling on the petitioners, how can the court enforce a ruling to bring the former president back? Pwede po ba yun? Mapabalik pa yung dating Pangulo?
Kaya nga, no, kaya in my view, the case has no legal leg to stand on. That will be thrown out by the Supreme Court. The first principle, the privilege of the writ of habeas corpus can only work within the jurisdiction of the country. What do I mean? The privilege of the writ of habeas corpus requires that the body of the subject of the petition be brought before the court and for the state authorities to explain why they are holding and depriving this person of liberty. And that is why it's a writ of habeas corpus, meaning it's a writ issued to bring the body of the subject. This is only effective when the subject is within the jurisdiction of the Philippine courts, because the court's order cannot extend beyond our shores, beyond our jurisdiction. Nobody will enforce this in The Hague now. Having said that, do you think the Supreme Court will place itself in a situation where they will be embarrassed, where the faith of the people would be eroded if they issue the writ to produce President Duterte's person before the court, when in fact they know it cannot be enforced, because really it cannot be enforced, and therefore, apart from the fact that really the arrest was valid, the court will dismiss this petition for the issuance of a privilege, for the invocation of the privilege of writ of habeas corpus.
Sir, as a last question, syempre po naging matulog din over the weekend yung mga sentiments naman ni Senator Bato de la Rosa following Duterte's arrest. So he said that he wants to seek refuge in the Senate in case he's ordered to be arrested as well. So up to what extent can the Senate protect Senator de la Rosa? Kahit po ba session break ay bawal siyang arestuhin sa loob ng Senado?
Sa akin po, the Senate cannot provide relief to Senator de la Rosa. Our Constitution provides that the members of Congress are exempt from arrest while Congress is in session and where the offense is punishable by imprisonment of less than 6 years. This presumes that that the warrant of arrest is issued by a local court, and it exceeds and it is for a minor offense where the penalty does not exceed 6 years, and Congress is in session. Obviously, these three conditions are not present here, and therefore the Senate is powerless to assert its jurisdiction. I was Senate President, and there were several instances when we went through this. What we do here is what we invoke as institutional respect for the Senate. For example, we have adopted the policy when I was the Senate President and followed subsequently that a warrant of arrest cannot be served in the premises of the Senate. You can serve because of institutional respect. You can serve the warrant once the accused is outside of the premises, but not in the premises of the Senate. I followed that. I imposed that policy because I know the limitations that the Senate has in trying to protect its members, and that is the best that can be done in the case of my friend Bato de la Rosa. The the Senate President can invoke that institutional respect for the Senate and prevent the service of the warrant on Senator De La Rosa. But other than that, the service of the warrant by the International Court of Justice on Senator Bato, assuming that there is one, is a question of the enforcement of our obligations under a treaty that the President must execute as a responsible member of the international community in order to serve the warrant on Senator De La Rosa. I repeat, it's a function of the executive branch pursuant to its authority as the chief architect of foreign policy and the service of the warrant by an international court of justice, international criminal court, is a matter of enforcement of a treaty obligation, and the Senate is not authorized to has no power to interfere in this, apart from the fact that under the Constitution, really the Senate has no power under the circumstances to prevent the enforcement of a warrant of arrest.
Okay, so just to be clear, para lang po sa ating mga viewers, hindi mapipigilan yung pag-serve ng arrest warrant kung meron man kay Senator Bato de la Rosa. Pero hindi po, dahil naging out of institutional respect, hindi pwedeng iserve sa loob ng Senado. Tama ba, sir?
Tama po yan kung respetuhin nung Philippine National Police ang tinatawag nating institutional respect. Hindi obligatory yun eh. That's addressed to the better discretion of the enforcers or the enforcers of the warrant of arrest.
Okay.
But strictly speaking, it is the Senate President has no authority, is powerless, even if he wants to prevent the service of the warrant on Senator De La Rosa. In the first place, it is not authorized under the Constitution. Second, the intervention of the Senate President is not authorized under the Constitution. Secondly, the service of the international warrant of arrest is a function of the executive in performance, in compliance with its international obligation, which has nothing to do with the local courts.
All right. Maraming salamat po, former Senate President Franklin Drilon, for enlightening us, for sharing your thoughts on this matter. Thank you, sir.
Thank you, Tristan.
And we will continue to deliver just the facts and the news you need. Until our next Newsmaker, I'm Tristan Udalo.